Senator.
Thanks so much, Mr. Chairman. I've got some concerns with this nominee who's been nominated to serve on the U.S. Court of Appeals for the Fourth Circuit. Among other things, she spoke on the topic of economic justice at Rutgers University. And while delivering those remarks, she compared the Republicans serving on this committee in reference to the confirmation proceedings of Justice Kavanaugh to union busters. And it's an interesting comparison, not terribly eyebrow-raising in and of itself, other than when you look at what she actually said, and her reasoning makes no sense. Certainly not the kind of sense one should come to expect from a life-tenured federal appellate court judge. She said, quote, despite the fact that multiple women have incredibly accused Kavanaugh of having sexually assaulted them, Senate Republicans allowed only one woman to come forward to testify. They ignored or belittled the other accusers. The fact that Dr. Ford was the only person allowed by Republicans to pretend the situation was she said, she said. These techniques were taken directly from the playbook of anti-union employers during union organizing campaigns. And yet, in sharp contrast to that assessment, which is wrong in many, many ways, didn't really hold herself to the same standard. Her own handling of an SEIU complaint involving a sexual harassment scandal demonstrated that she sometimes does think women who accuse men with authority over them in cases involving sexual harassment perhaps should be ignored. At least that's how she proceeded. She failed to disclose to this committee her involvement in the sexual harassment problems, prominent problems within SEIU. And second, her actions in that particular case, as detailed in an expose published by a pro-labor website, the Payday Report, appear to show that she declined to meaningfully investigate multiple serious allegations of sexual harassment by SEIU officers and affiliates. She declined, despite the obligation to do so, to disclose her candidacy in the 2020 World Zionist Congress elections, despite the fact that it was clear she was required to do so. She failed to disclose a 2020 letter taking some strident positions regarding Israel and its approach toward Judea and Samaria, even though she was required to disclose that. She holds some pretty radical union labor-focused views, including promoting policies that would make it illegal for an employer to inquire about a worker's immigration status during an organizing campaign, requiring prisoners who work in prison to be entitled to labor law protections, including minimum wage. She promotes policies of workplace councils, which would require 40% of corporate board seats to be controlled by workers, and requiring a supermajority of board members to make corporate decisions that directly affect workers, such as decisions to declare bankruptcy, close a plant, lay off a significant number of workers, and so forth. And she said, quote, at its core, the right to work movement is deeply racist. Interesting and indefensible. She opposed the planned Catholic community of Ave Maria in Florida because, as a staff attorney at Planned Parenthood put it at the time, she determined that the community would favor a pharmacy that would not sell birth control and banning one that sold contraceptives altogether. That's a quote. Her name appeared on an SEIU brief in Reproductive Health Services of Planned Parenthood of the St. Louis region versus Parson. The case concerned whether Missouri's prohibition of abortions performed solely because of Down syndrome, solely because the baby being aborted had Down syndrome, was per se valid. You couldn't protect a baby with Down syndrome on the basis of it having Down syndrome. She even went so far as to argue that such protections for babies with Down syndrome would be patently unconstitutional. And she has said that Margaret Sanger, the infamous eugenicist founder of Planned Parenthood, is one of her childhood heroes. These statements concern me, and they don't reflect the careful, reasoned judgment of someone with whom we should be entrusting a life-tenured position as an appellate court judge. Thank you.
Thanks to all of you for being here and for your willingness to serve. Judge Bulsara, I'd like to start with you. There's an organization that you belong to called the National Asian Pacific American Bar Association. You've been a member of it for the last 7 years. It's abbreviated sometimes as NAPABA. NAPABA has made a number of comments over the years, and I understand that someone can belong to an organization without necessarily embracing every statement that that organization makes. Nonetheless, there are some of these statements that I'd like to know, I think others on the committee would like to know, whether you agree with them. Among other things, NAPABA has publicly taken the position, quite aggressively, that no sanctuary jurisdiction, that is a city, municipality, or local unit of government, may be denied federal funds or may have any federal funds withheld on the basis of that entity refusing, declining to cooperate with federal immigration law enforcement authorities. So they take this opposition to any legislation that would withhold any federal funds to sanctuary cities. Even worse than that, NAPABA goes a second step and states that it believes that states and localities that decide to be sanctuary jurisdictions, that is, that don't honor ICE detainer requests, deserve, in fact, to be rewarded with additional financial support. Now, do you share this view, that sanctuary cities ought to be rewarded and never have federal funds withheld for refusing to cooperate with federal law enforcement?
Thank you, Senator. I think, as you may appreciate, NAPABA has several 100,000 members.
Sure.
I'm only one of those members. I'm not an officer director. I'm certainly not familiar with the class of statements that you're addressing or any press releases to that effect, and I've never read any NAPABA statement on these particular items that you've identified, so I can't...
So you were not aware they had taken this position?
I was not, Senator.
Do you agree with that position that they've taken?
Senator, I can't agree or disagree with the position because the issues you've identified, not only do they come up in our courts, they're likely to come up in my court.
Actually, I'd push back on that. This is a legislative determination. This is almost impossible that it could come up in your court. And keep in mind, this is a core function of the federal government. It is only the federal government, under Article 1, Section 8, that has the authority over our immigration laws and consequently over the enforcement of those laws. This is the prerogative of the federal government. And yet you're saying that a local jurisdiction that refuses to cooperate with that should not have federal funds withheld, or the entity is saying that rather. Now, a legislative determination, again, I don't think this is something that could or would come up. But let's move on. NAPABA has also opposed legislation, H.R. 734, the Protection of Women and Girls in Sports Act of 2023. Do you believe that males should compete against females in sports?
Again, Senator Lee, I can't comment one way or another about that topic, in part because in Long Island, just as an example, there are states and there are local and county legislation that's been passed in the recent weeks. Those laws are under challenge. Those cases are being brought in the Eastern District of New York. I simply cannot comment about issues that bear on litigation that are before me.
I understand that you're declining to answer. Keep in mind, you are a member of an entity that has made those statements. And if you can't comment on those statements, then perhaps, as a judge and as someone sitting for a nomination to be a lifetime appointed federal judge, then perhaps the answer should be that you shouldn't be a member of the organization. But it does raise an inference as to whether you do agree with them, and I note for the record that you're declining to do that. Now, NAPABA filed an amicus brief in a case called Students for Fair Admissions versus Harvard. I'm sure you're familiar with that case. It went before the Supreme Court and was decided about a year ago. And in that brief, it called for, quote, consideration of race as a factor in college admissions. Do you believe that some students should either lose or have lower access to educational opportunities in higher education based on their race?
Well, I think, Senator, the Supreme Court has clearly said no, and it's my current oath. And if I'm
You'll stick with that.
and I
Now, NAPAMA also called the Supreme Court's ruling in another case, 303 Creative versus Elenis. It called it misguided. Do you also believe that that decision was misguided? Do you share this view? And how should the case have been decided if it, in fact, were misguided?
Senator, I'm not familiar with that statement, but I never refer to Supreme Court decisions in that way because of my oath to follow them, and it would be inappropriate for me to disparage decisions and then uphold my oath to follow them.
Okay. My time's expired. Thank you, Mr. Chairman. I do note here, look, if you're going to belong to an organization that engages in advocacy, you can't have it both ways. You can't at once say, I know nothing about that, and then decline to say anything about it and belong to that organization. I think you ought to have to answer the question. Thank you.
Senator Ossoff.
Thank you, Mr. Chairman, and congratulations to the nominees. Congratulations to your families for this honor as well. I'd like to begin with an initial question, just like a yes or no answer, moving left to right.
Thank you, Mr. Chairman. Thank you, Judge Maldonado, for being here. When we look at the work of a federal district judge, it's a busy docket. One has a lot of motions to follow and to stay on top of. Some of the motions that end up taking a lot of time are on the civil docket side of things, motions for summary judgment. In your view, what's worse, when you've got a close case, to grant a non-meritorious dispositive motion or a Rule 56 summary judgment motion, or to fail to grant a motion for summary judgment where it is warranted? In a close case, which one is worse, or is either worse?
Thank you, Senator Lee. So I am very careful with motions for summary judgment because I respect the role of the jury. And I think it is rather arrogant for me to decide there's no disputed issue of material fact. And so I inherited, I don't know, tens and tens of motions for summary judgment, and I take those very seriously because I don't want to take someone's day in court away from them and usurp the role of the jury. Sure. So those are the most time-consuming motions that I have before me. And just to clarify, when I received my reassignment, many motions that I received were from 2020, 2021, and so I had to triage and have a pipeline and decide the oldest first, and that was sort of my plan of attack, to decide those older motions first.
Okay, that's helpful to know. So it sounds like you may have gotten assigned some dogs when you arrived. It happens sometimes with the newly arrived judge. It's sort of a hazing ritual among some judges. The reason I ask about the dispositive motion issue is that there's a natural tendency among judges, including federal district judges, to want to not face the more difficult decision whenever they can avoid it. It is more difficult to grant a motion for summary judgment than it is to deny one. And you're subject to appeal much more quickly, more likely to get reversed, and if you deny it, the parties might well settle and call that trial by attrition. It's a list of paradoxes that exist in the court, in the judicial system. On the one hand, justice delayed is justice denied. On the other hand, as evidenced by the turtles on display in the courtyards at the Supreme Court across the street, sometimes the deliberative process needs to be deliberate and it needs to be slow-paced. And so those tensions have to be managed. But the risk we run into is the judge looking for ways, perhaps, to minimize the judge's exposure to being overturned on appeal and the workload. Granting the motion for summary judgment requires you to write an opinion or order, which takes time and can be immediately appealed. Now, of these cases that you've got, I think it's 125 pending motions that you've got, ranking you as number one in the Seventh Circuit, number 7 in the nation. There are some that are troubling, some that including one that was filed by a prisoner. This is not complex multi-district litigation involving huge mega corporations. There's one, for example, that's been fully briefed since November 2021 for 3.5 years nearly. we call this a fully ripe motion for summary judgment. The prisoner in this case filed the case complaining that he's while in prison suffering extreme tooth pain. It's apparently going unaddressed while he's in prison. They've done everything they can to get it teed up. It's fully briefed. It's before you. And just last month, the plaintiff submitted another status report request of the court. And your response was, quote, "The court has taken defendant's motions under advisement and will endeavor to rule on both in the near future." What does that mean here, endeavor to rule? And what more would you need to rule on a case of that relative simplicity in less than 3.5 years?
Thank you, Senator. So do you happen to know the name of that case?
We can get that for you.
Okay. So there is a triage process that I follow in my chambers. We're generally working on the oldest motions. And I think reading what you just wrote, listening to what you just read to me, I think this means it's in the immediate pipeline, meaning that it's in the top, 10 things that are immediately going to be issued. Now, I am a very involved judge. I edit every single thing that goes out of my chambers, and so oftentimes and I go back and forth with my law clerks on drafts. It's not sometimes the most rapid process,
But does this case ring a bell? Do you recognize?
If I knew the name, it's probably, with all my law clerks, we have our list of things that we're working on, our pipeline, which has to be based somewhat on chronology. So you mentioned November 2021. I wasn't even on the bench yet. And so that came to me almost a year old.
Right.
And that wasn't even one of the oldest.
It was fully ripe before you became a judge. And
a year before I became a judge.
And I understand that sometimes new judges, part of this hazing ritual that I described, get assigned dogs, get assigned a long list of cases with pending dispositive motions. I understand that happens. But we will get that information to you. I raise it simply because it is very important that we not drag those out. At some point, it becomes trial by attrition, and the parties lose a lot when justice is delayed. Thank you, Mr. Chairman.
Thanks, Senator Lee.
Chair.
Thank you, Senator. Senator Lee.
Thank you, Mr. Chairman. Thanks, Mr. Ritz, for standing for this nomination and for being here today. Now, it's my understanding that you were subject to an ethics investigation by OPR. Is that right?
Never in my career.
Never. But you're aware of the situation in United States versus Von Rico Weber, where you were accused of making these material representations to a defendant's attorney in order to elicit a guilty plea.
I have some recollection of that, Senator, but I was not subject to any sort of formal complaint or investigation.
Okay. Well, it's my understanding that in this circumstance, this would have resulted in the defendant serving a 10-year prison sentence, and the accusation is that you led the defendant to believe that a low sentence, a much lower sentence, would be in order, or perhaps even probation. I just want to read to you the letter, the email that we received from the concerned defense attorney, shining light on the incident. The person writing this email is recounting a conversation with the defense attorney in which you allegedly misled the defense attorney and the defendant. After the defense attorney explains it, here's how he explains it. At this point, I stopped the conversation and said, "Was the AUSA Kevin Ritz?" The answer was yes. It is unfortunate that this is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution. It is a sad commentary. This is a concerning allegation, of course. Now, I assume that you would agree, certainly, that misleading a criminal defense counsel as to the nature of the charges against the defendant and the likely sentence that might result from a guilty plea that would violate a federal prosecutor's ethical responsibilities.
Yes, and I did not do that in that case, Senator.
Now, my understanding is that a complaint was made against you with the Department of Justice Office of Professional Responsibility and that an investigation ensued. At what point did you become aware of that investigation?
Again, Senator, to my knowledge, there was never an OPR investigation or a complaint for that matter.
Okay, so you're not aware of anything like that?
That's correct.
Does the information you just heard, the accusation, does that reflect your pattern of behavior as a prosecutor?
Absolutely not. And I recall this, and I recall that the person who had sent that email communication certainly had not communicated with me. I'm not actually sure we had ever had cases together in the first place. In any event, I took action, and I believe I communicated with everyone who received that, because in our federal district, it's really important for AUSAs and defense attorneys to be able to trust each other. And sure. I took my reputation very seriously.
Okay, but you would agree that if you had done those things, which that had resulted in a complaint to OPR and you didn't disclose it, either of those things would be a problem?
If I had acted unethically, absolutely, but I did not.
Now, as you know, one of the most important decisions a U.S. attorney can make is the decision about whom to hire as a first assistant U.S. attorney. Would you agree with that?
Yes.
It's a pretty important thing. It's why I find it disturbing that you chose to hire Ms. Reagan Taylor Fondren to serve as your first assistant, despite the 2 disciplinary investigations that she was under for serious accusations relating to ethics violations. As a former federal prosecutor myself, I know that the fairness of the justice system depends a lot on, among other things, how prosecutors handle things like exculpatory evidence. And withholding exculpatory evidence from defense is a big problem. Ever since Brady versus Maryland was decided in 1963, every prosecutor knows that there is an obligation to disclose these things. Now, when you chose Ms. Taylor Fondren to be your first assistant, were you aware of the 2 ongoing investigations of her alleged prosecutorial misconduct related to failure to disclose exculpatory evidence?
I may have been aware of ongoing proceedings. My recollection, Senator, they were not. They were still proceeding, and I honestly can't remember if they still are today.
So they were pending at the time you chose her. Were you not concerned about that?
Senator, I am not sure I knew the particulars of the situation.
In fact, she began your service as a first assistant before her court-ordered suspension from legal practice was enforced. Is that right?
I believe that's correct, Senator. I'm not actually entirely sure.
Now, a man served 4 additional years in prison because of the misconduct of your first assistant. Now, thankfully, the Court of Appeals corrected her error, but not for the full 4 years. And so, was it in spite of or because of Ms. Taylor Fondren's willingness to violate the defendant's constitutional rights that you chose her to be your first assistant?
Senator, as I said before, I believe that Ms. Fondren and all of our AUSAs are doing an excellent job keeping people safe in West Tennessee. These allegations and this incident occurred, I want to make clear, before Ms. Fondren was part of our office several years ago.
But you were aware of the accusations?
I was aware in a very vague sense.
Thank you, Senator Lee. At this point, I'd like to put in the record a letter from Van Turner. Are you familiar with Senator Lee?
Thank you, Mr. Chairman. I want to follow up with Judge Nett Byrne regarding the JJS case. I've been reading through your report and recommendation, and I just want to review the fact that this was an individual, JJS, who had raped a 9-year-old boy, raped a 17-year-old girl, was put in prison, went to prison for a long time. After that person was paroled, JJS, the way you put it on page 44 of the report and recommendation was that that JJS sent 2 sexually explicit images of minors in 2015 while out on parole. I should point out this is kind of a euphemistic reference. These were not just sexually explicit images. These were sexually explicit images of adults violently molesting children, sexually assaulting, abusing children violently. Every time this person has had an opportunity to offend, this person has offended. And yet you recommended this person against the recommendation of the U.S. Bureau of Prisons to go to a women's facility. Now, your reasoning here is stunning to me. Going back again to page 44 of your report and recommendation, you say, quote, "There are no signs that petitioner is at risk of reoffending." I'm struggling to understand how you could possibly conclude that, because the minute this person was released, this person engaged in other offenses. Yes, not a contact offense while out on parole, but there are still issues going on. It says nothing. You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are among the worst crimes that we see. This person was convicted by guilty plea 30 years ago of 2 awful crimes and was sentenced to a very significant prison sentence by the state court judge. About 8 years ago, the petitioner committed another awful crime, the crime of distribution of child pornography. That is an abhorrent crime, and there are real victims. And the petitioner was sentenced by the Indiana federal court.
I understand this. This is all undisputed. What I want to know is, why is it okay? Why is it safe? Why is it fair to female inmates to send this person to a female prison? This is a guy who raped a 17-year-old girl and a 9-year-old boy. Why is that safe? 6'2" biological male.
Senator Lee, as I do in every case before me, I look at the record evidence. I consider the facts before me. In this case, the facts that I considered included that every single warden who supervised this petitioner recommended that the petitioner be transferred to a women's facility because of her serious medical needs, because she had engaged in no violence, no infractions, and in fact had been the victim of sexual assault.
While in a male prison, and this was against the decision of the U.S. Bureau of Prisons. Judge Valenzuela-Dixon, do photo ID laws violate the U.S. Constitution? Does it violate the U.S. Constitution to require someone to show identification when casting a vote? Does it violate the U.S. Constitution? Is it unconstitutional?
Please turn on your microphone.
Thank you.
I asked because you submitted a brief in a case called Crawford versus Marion County Election Board. And in your brief, you argued, quote, the striking similarities between voter identification laws and poll taxes this court rejected less than a half century ago demonstrate that identification requirements are unconstitutional regardless of the level of scrutiny the court applies. The court, of course, disagreed with your assessment.
It did.
So what's your answer to my question?
The Crawford case made it clear that voter identification laws are constitutional, and I would follow that precedent.
Do you agree with that precedent?
That photo ID laws are constitutional?
Yes.
I do, Senator.
And yet you argued to the contrary in that case. Did the court convince you?
Well, the court stated what the law is, so I would follow the precedent of the Supreme Court.
Thank you. Ms. Campbell, I'd like to start with you if we can. According to FEC reports, the largest donation that you've made to a candidate is a $1,500 campaign contribution to Odessa Kelly, candidate from the Tennessee 7th Congressional District. Does that sound right to you?
That seems accurate, yes, Senator.
Now, look, this candidate, Ms. Kelly's made some pretty crazy statements. Are you aware of those?
Senator, I suspect that some of the statements you're going to ask me about were after her candidacy, and no, I have not. I don't follow her on social media. I don't have Twitter, so.
All right. Well, you don't have Twitter, but look, she made some really awful statements, including the following tweet just 4 days before, not after she was a candidate, not before she was a candidate, while she was a candidate, and just 4 days before you contributed to your campaign. Here's what it says. Like Cory Booker said, hashtag Ketanji Brown Jackson, God has got you 100%, because Blackburn, Cruz, Cotton, Graham, Hawley are obviously aligned with the devil. Apparently I'm not. Be great, black woman, be great. The hate is real, the racism is apparent, the disrespect is on another level. Now, this tweet, which is a public statement, attacked some members of this committee, a lot of members of this committee, as being, quote unquote, aligned with the devil. What does that mean? I mean, do you agree with Odessa Kelly that members of this committee, the members that are mentioned in this tweet, who happen to have opposed Justice Jackson's nomination, do you agree that that means that they're racist, that they're the devil? Would the same apply to those senators who criticize Justice Clarence Thomas, or to those who voted against his confirmation when he came through this committee?
Senator, I am not familiar with those statements, and I do not support them. Okay.
I understand that, and I understand that you're not on Twitter, but this is a candidate that you donated to. Now, I'm willing to assume that that's not the only crazy statement she's made. And in fact, it's certainly not. On January 11th, 2022, only a few months before you contributed to Odessa Kelly, she tweeted, quote, let me make this simple. 41 million people in the U.S. and the USA ID as AA/BLK, and their ability to have fair representation is being decided by 52 white people in the Senate, including Tim Scott. 48 Republicans plus 2 Ds. That's insane. Now, I don't know what that means by white people, including Tim Scott. I think Tim Scott would probably take exception to that. How is this tweet calling out our black colleague, Senator Tim Scott, how is calling him white not racist?
Senator, again, I'm not familiar with that statement. I have no affiliation with that statement. I don't know what some of the acronyms
Do you share those
in that
views?
statement.
Do you share those views?
No, Senator, I do not.
All right. Now, according to your AVO profile, you've been legal advisor to an organization called Workers' Dignity from 2013 to the present. Is that correct?
Senator, I have never represented Workers' Dignity. A long time ago, I was on a legal advisory board to help them.
So you have been a legal
started.
advisor. You have been a legal advisor to them.
How come you didn't tell me that?
I apologize, Senator. I have never represented Workers' Dignity. I was on an advisory board about 15 years ago to when they were starting.
Okay, and when did your work for Workers' Dignity end?
I'm sorry, can you
You talked about that it was a long time ago. When did it end? When did your work for them as a legal advisor end?
Senator, I would guess in about 2012 or 13.
All right. Now, according to your AVO profile, on June 12th, according to that profile, you authored an endorsement for an attorney named Raquel Lee Bellamy on June 12th. So, at the least, you should have been aware that your AVO profile listed that you were currently a legal advisor to Workers' Dignity. Were you aware of this?
I was not, Senator.
You were not aware of the fact that even though June 12th, now June 12th, that's just a week ago yesterday. Tell me what I'm missing here. Because you authored an endorsement for an attorney named Raquel Lee Bellamy on June 12th. So were you not aware that your AVO resume listed that you were currently a legal advisor to Workers' Dignity?
Senator, I believe it's been more than a decade since I looked at my AVO profile, and so I was not aware that it said that.
More than a decade or more than a week? Which one?
I have not looked at it. Are you suggesting June 12th of this year?
Yes. Yes.
No, that is incorrect, Senator.
Okay, but you can't tell us when it ended. You haven't told us really when it began or when it ended. A minute ago, you didn't acknowledge to Mr. Grassley what was going on, so I'm a little confused. I'm about to be gavelled out. I'm out of time, but this raises some questions. It also raises some questions. Your largest political campaign donation went to someone who has made blatantly racist comments and really wildly inappropriate comments about almost every member of this committee, and I find that troubling.
Thanks. Can I, first of all, welcome. Glad you're here. Wish you well. This is a bit of an...
Thank you, Mr. Chairman. Judge Wise, why don't we start with you? Until earlier this year, you served on the board of the Alameda County chapter of Girls, Inc. Now, this is an organization that seems to do some good things, helping disadvantaged girls, but is one that's also taken some radical positions on sex, on gender. Girls, Inc.'s definition of gender states that, quote, a girl is a young person who identifies as a girl, regardless of her assigned sex at birth, or who identifies as a girl while exploring gender identity or expression, close quote. Do you agree with this definition?
Good morning, Senator Lee. First, I will say that I believe what you're reading from is a policy regarding Girls Inc. National, which I think might be out of New York. My only role has been in the limited capacity in Alameda County, where I am. I have no familiarity with the remarks that you made. I'm not familiar with those comments.
You agree with them?
I mean, what I know of Girls Inc. is that it focuses on girls in our community, primarily starting at kindergarten for literacy.
Do you share the view expressed in the statement?
I don't have any opinion about those particular remarks from Girls Inc. National.
We've heard from many women, many of whom are sexual assault survivors, parents of girls, about the physical and psychological risks of being forced to share bathrooms, locker rooms, other facilities with biological males. Mm-hmm. Now, this concern is far from being just hypothetical. It's not one that's just being dreamed up. In Loudoun County, Virginia, just a few miles from here, a 15-year-old boy wearing a skirt and claiming to be a transgender girl was convicted of sexually assaulting 2 girls in girls' bathrooms at school at 2 different high schools. Now, the schools allowed him to be in the girls' bathroom because of the same bathroom policy that, from what I can tell, you seem to have advocated for. Now, have you considered how your advocacy and the positions you've taken on this front might adversely affect girls?
First of all, I will say I think there might be some confusion about the article that I wrote. The article that I wrote took no position about who should be able to use a bathroom. Everyone should be safe, including girls and women in all bathrooms, in locker rooms, everywhere. All of us should be safe. I care very much about the rule of law. I wrote nothing about people who are gay or straight or transgendered at all. My article had nothing to do with that.
Well, here's one of the things you say in that article. This is going back to the Time magazine article. Quote, if modern science recognizes that sex has countless natural permutations, and if birth certificates, physical observation, and even chromosomal testing cannot reliably categorize every individual as either male or female, then our judiciary cannot be required to make gender findings antithetical to that reality. Could that not be extended to cover the kind of situation I described in Loudoun County? In other words, if you've got a bathroom policy that says that if you are a biological male, and have been identified as such because you have male characteristics. You may not use a female bathroom.
I'm not sure if you were here a moment ago when I was speaking to this issue. My very limited concern were about children at the moment of birth who a doctor cannot properly assign as male or female.
I understand that, but I think you would agree the quote I just read to you goes well beyond that. And so it's one thing to make the statement, as you were suggesting a moment ago, one that might apply in one out of 120,000 cases where you've got a very rare genetic abnormality or something like that, Klinefelter syndrome or something of the like. But the statement I just read is much broader than that, is it not?
So the statistics I am familiar with the World Health Organization indicates that it's approximately 1 in 2,000, 1 in 20,000 that are serious. That is a baby born every other day. I think that
the 1 in 2,000 figure is based on much different criteria, and it's not actually intersex positions. We're running out of time. I want to turn to Ms. Provenzino for a moment. Ms. Provenzino, you spent some time with the Advocates for Human Rights. This is a group that has at times taken some very radical positions. Now, among other things, they've made statements suggesting that they see their more conservative neighbors as oppressors, stating, quote, today's anti-transness and anti-queerness is largely rooted in Euro-American colonialization. Forced assimilation into Christianity is part of the process of cultural genocide and the imposition of a gender binary and normative forms of sexuality. Do you stand by your association with this group, and do you agree with that statement?
I worked with Advocates for Human Rights as the inaugural Wellstone Legal Fellow immediately after clerking for Judge Diana Murphy. That was in 2004 to 2006. I have no familiarity with these statements, nor do I take any position on them, Senator.
Okay, so you don't disagree with them now. Let me just ask one more follow-up question. I'll be done. The same group has made some other statements touching on things within the state of Minnesota. Last year, the group wrote about racism in Minnesota. Quote, this was an unprecedented opportunity of the Twin Cities community to address the systemic state-sanctioned violence against black and brown communities in Minnesota. Time and time again, Minnesota's elected leaders have failed to make meaningful change in the state's law enforcement practices and accountability mechanisms. Now, do you believe that the state of Minnesota and its elected officials are fostering state-sanctioned violence against ethnic minorities?
I'm not familiar with that statement, but as you're phrasing it and explaining it to me, I do not agree with that, Senator.
Okay, I see my time's expired.
Thank you, Senator Lee. Thank you very much. Senator Klobuchar?
Very good.